Good morning, this is your Kelso Report for Tuesday, February 7th, and I'm your host, Clark Kelso. 20 years ago, the Ninth Circuit held that a defendant seeking to exclude evidence of a prior removal order in a prosecution for illegal re-entry must do more than demonstrate a violation of due process rights. The defendant must prove prejudice. In United States v. Reyes-Bonilla, the defendant alleged the removal order in his case was the result of a hearing where he was not advised of his right to counsel. The Ninth Circuit held yesterday that this type of error did not establish per se prejudice for the purposes of a collateral attack on the removal order in the context of the defendant's criminal prosecution. And since the defendant did not establish actual prejudice, the court affirmed his conviction. Next, we have two California Supreme Court cases affirming death penalty sentences. They unanimously affirmed in both. In People v. Fuyava, it took the court 135 pages to affirm, and in People v. Enraca, only 42 pages were required to affirm. Both had the usual sets of meritless grounds for appeal. The California Court of Appeal, criminal sentencing, first. The United States Supreme Court had held in Graham v. Florida 2 terms ago that the Eighth Amendment's cruel and unusual punishment clause was violated when a minor convicted of a non-homicide offense was given a no-parole life sentence. The court left open the question of whether a no-parole life sentence could be imposed upon a minor convicted of a homicide offense. Well, in People v. Murray, the 2nd District followed the 1st District's recent decision in People v. Blackwell and held that such a sentence may indeed be constitutionally imposed if a minor has been convicted of a homicide offense. So that gives us 2 districts that have upheld that type of a sentence against a minor in a homicide. Our last case today is an important class action decision from the 1st District. Now, there is always a tension in class action procedures between our due process ideal of providing individualized justice in each case and the practical realities of adjudicating scores, hundreds, or thousands of cases, all of which share common questions of fact and law. But the trial court in Duran v. U.S. Bank National Association took the general idea of mass adjudication a few steps too far. The plaintiffs were 2 employees of the defendant who represented a class of 260 current and former business banking officers who claimed they were misclassified by the bank as outside sales personnel exempt from California's overtime laws and were thus unlawfully denied overtime pay. The trial court adopted a case management strategy of relying solely on evidence derived from a 21-person sample to determine class-wide liability and restitution. Well, the sample was not even randomly selected, and it was so small that there was a 43% margin of error in weekly overtime hours. In short, it did not produce statistically significant results. And on these facts, the 1st District held the case management strategy was invalid and inappropriate. And the 1st District not only reversed the liability judgment, it decertified the class. This is a big victory not only for this one defendant, but for the many businesses that are now facing wage and hour class actions. A decision affirming liability would have opened a very wide door to what I would describe as essentially lazy class actions. And that's it for today's Kelso Report. Have a great day in the law.